SJC-12086, Commonwealth v. John F. Squires III, and SJC-12087, Commonwealth v. Stephen Angier.
Morning, Ms. Hill. If you'd wait one moment, we are very sorry you have to make this argument. So, our condolences to the family. We don't know how he died, but we're... So, tell us what you think happens as a result of his death.
Yes, good morning, Your Honors. The facts of this case are that on April 4th, 2016, we filed this court allowed a petition for further appellate review. On June 5th, 2016, Mr. Angier served his sentence. On June 4th, he called me. At that time, we had a discussion about the direction of how the appeal was going, and he clearly indicated that he wanted to continue with the appeal. I filed the brief on June 30th. I was not able to reach him prior to then. I also had surgery, major surgery, on June 20th. The brief was due on June 20th. So there was a bit of a time where Mr. Angiers knew as well that we probably wouldn't be in touch. Immediately thereafter, I continued to try to reach Mr. Angier. I was not able to get in touch with him. I contacted my brother, and through Mr. Squires, who is the co-defendant, it was not until September 9th that I learned that he had passed away. Immediately thereafter, I went to the Department of Vital Statistics to confirm that he did indeed pass. I obtained a death certificate, and on the 13th of September, I filed a suggestion of death. I also moved to vacate the judgment. No opposition entered, and it was my understanding that the appeal would be dismissed and the judgment would be vacated. However, my sister has filed an opposition on Monday with regards to this, and I think where we stand in difference is what should be done with the complaint. I think it's the position of this court that the appeal should be dismissed and the judgment should be vacated and the complaint should be dismissed. We are in the majority jurisdiction where we apply this rule that when an individual dies while an appeal is pending, the appeal is dismissed and the indictment or the complaint.
Is that true also like with certiorari
no.
in the U.S. Supreme Court?
No, Your
I mean,
Honor.
does it matter that this is here on further appellate review?
I don't think it matters. I think further appellate review is still further direct review. Direct appellate review starts and ends in the SJC. Pursuant to Rule 11, all criminal defendants have a right to direct review, and then all criminal defendants have a right, pursuant to Appellate Rule 27, to end in the SJC.
So this wouldn't apply to a motion for new trial, for instance. This is part of the direct review.
This is direct review, yes, and this wouldn't apply in this instance. And that's why I think Commonwealth versus Della Zerta does not apply in this situation, because in that case, the issue was whether or not is it direct review or is it collateral review. And of course, a Rule 30 motion is collateral review. So in that case, that doesn't apply in this instance. And the policy reasons for vacating apply in this case. There are two policy reasons. One is whether or not to forestall the imposition of sentencing. In this case, that doesn't apply because he completed his sentence. And the second policy, the rational rule which we follow in Massachusetts, is that a defendant shouldn't stand convicted without resolution of his appeal.
But that's I guess my question, is that shouldn't stand convicted without resolution of his appeal, but you have a right to apply. You certainly don't have a right to further appellate review. I mean, in that way, it's sort of like certiorari review if you had a federal conviction.
No, but all defendants have a right to apply for further appellate review, and this court accepted the further appellate review on April 4th, 2016. Therefore, this case was not resolved, the conviction was not final, and that's where the issue turns on. when deciding whether or not it should be dismissed below, is the finality of the decision. So,
As a practical matter, let's assume your client were alive right now.
yes.
If the result of the appeal, or of the further appellate review were a reversal of the conviction,
I don't think
it
that would.
doesn't matter? to
No,
you?
it would not matter because the issue that is applicable here is mootness. And so because he is dead, the case is moot. It cannot attach to him subsequent to his death.
Okay, thank you.
Thank you, Your Honors.
Ms. Healy, we'll hear you only on this issue, and then we'll hear from Mr. Michaud.
Yes, thank you, Chief Justice, Associate Justices. Good morning, may it please the Court. Carolyn Healy for the Norfolk District Attorney, and present with me is Assistant District Attorney Michael McGee, who is the trial prosecutor. In this situation, Your Honors, following De La Zerta, the proper procedure is to vacate the allowance of further appellate review and let the conviction stand, where Mr. Angier's already had a direct appeal and his conviction was affirmed by the appeals court.
Now, what if Mr. Squires is declared by us to be not guilty because of the insufficiency of the evidence? Would it be fair for Mr. Angiers to have a conviction where Mr. Squires did not, based on the same evidence?
It would be fair, Your Honor. The evidence is slightly different as to each of the defendants, and I would suggest that this court should not vacate
Well, we'll
Mr.
get to
Squires'
that. I'm not
case.
suggesting that
But
we come
Mr.
to that
Angier's
view.
already had a direct appeal, and his case was affirmed by the appeals court. And if his case were to go forward, this court would be hearing an appeal that would make no difference because he's already served his sentence and he's deceased. If the court,
But what do you say to the argument that De La Zerta, if I understood correctly, was a Rule 30 motion, so it's collateral? It's a collateral.
it's a collateral appeal, and in that case, if there's already been a direct appeal, the conviction should be affirmed. But I analogize the allowance of further appellate review here to a petition for certiorari that's either pending or been allowed in the United States Supreme Court, because it's a further appellate review beyond what the appeals court has already done. It's not a matter of right, and in terms of public policy interest, there's already been an appellate court that has reviewed the findings of the jury in the trial court, as well as whatever happened in the trial court, and affirmed that conviction. So I think the correct procedure is not to abate the conviction here, and that would leave Mr. Angier as if he had never been charged at all. It would go back ab initio. But the correct procedure is, because he had already been tried, convicted, because the appeals court had affirmed the case, in the interest of public justice, in the interest of not hearing a case that's moot, the proper procedure is to vacate the further appellate review, allow the conviction to stand.
What would be the harm in allowing the case to go forward and whatever happens, happens?
Well, if Mr. Squires were not part of this case and it were just Angier, the court would be...
Given that there is a Mr. Squires who is involved.
I think there's a public policy problem in allowing a case to go forward for an individual who's deceased. The facts are slightly different as to each co-defendant, and so the court would have to make findings as to each individual. And the end result is that it makes no difference. He's already served his sentence, he's been convicted, the conviction's been reviewed, and the court would be spending its time and analyzing these facts in a case
But we have to analyze it anyway because we have Mr. Squires.
But because Mr. Squires is the only remaining defendant, this court, I suggest, needs to analyze it with an eye towards Mr. Squires and his role in this case.
Well,
in this
do you
case,
suggest that the appeals court or any other court has treated them differently?
no, I don't suggest that, Your Honor. But I could envision a case in which the co-defendants were positioned differently.
Yeah, that's not this
In this case, they're
case, though.
fairly similar. They're walking together, and I'll get into the facts a little bit later, but
I'm sorry, are you saying that the insufficiency of the evidence argument might be different as to each in this particular case?
I don't suggest that in this particular case. They're very, very similar, but they are different people. They were in possession of different items, and if the court finds that under de la Zerta in this situation that the case needs to go forward and be heard, the court might find itself with co-defendants that are in very different positions, one of them being deceased, the other one being here and being able to form and direct his attorney's appeal, and being very different positions in terms of the facts, and then having to make findings as to both of them.
Okay, thank you.
Thank you.
We'll see you back momentarily in 15 minutes. Mr. Michaud.
Good morning. I represent Mr. Squire. There are three primary issues here, the most important of one, which I believe is the intent of the defendants. The intent with respect to whether or not there was any proof or any evidence of any intent to go towards any place, building, establishment, et cetera, with the intent to burglarize any one of these establishments. The facts that were presented at court were that the defendants walked past numerous buildings, a China-Rama Chinese restaurant, the White Hen Pantry, I believe it was, and a doctor's office, a gym, and then some other buildings. They walked past those buildings, and from the testimony was that they walked roughly 15 minutes to 20 minutes in the direction of railroad tracks, went on the railroad tracks, did not veer from the railroad tracks, turned around on their own, and came back, and then were approached by the officers. So the primary issue, again, is that I believe that there is, and the defendant believes that there is no evidence of any intent by the defendants to go towards any establishment. That, in and of itself, should show that there was insufficiency of the evidence. The items that were
Well, I mean,
found.
certainly if they had burglarious tools that were specific to the commission of burglaries, they would not have to show that they were going in that direction, would they?
I agree, 100%. The problem with this case is that these tools were also tools that could be used for ordinary use in construction. Not only that, they had a map that there was never tied to any building. There was never suggestion that that map was tied to any building or any place by the Commonwealth. The defendant presented evidence or testimony that that map was connected to a girlfriend's apartment.
So that map really doesn't help you out much, does it?
Oh, I agree. It
really doesn't look good.
I agree that the map, it's
not good.
No, I agree. But at the same time, the Commonwealth did not connect the map to any building. So I guess the question would be is, in a set of facts where somebody walks out of their vehicle, certainly if they walk towards a closed building late at night, which this was late at night, with a map, even if that map didn't associate with that building and they had those tools, I could certainly see the conviction standing. But in this case, they walked completely away from any buildings. They walked down 75 yards.
You think it's like the case where the vehicle was pulled over? I forget the name of the case, but you cited the case where the vehicle was pulled over. They had tools, and the court said not enough. We don't know where they were going.
It's slightly different, but at the same time, again, they walked so far away from many buildings. I think that's.
How far was it? I mean, where were they on the tracks when they were stopped?
They walked 15 to 20 minutes. That's what the testimony from the officers were, that they had to follow them for 15 to 20 minutes. The actual length on the path, I believe, was testified by the police to be 75 yards away from them, and the defendants testified it was roughly 100 yards. But in any event, it's at least 75 yards. And in page 55 of the 44 of the transcript, the officers admitted that they did not make any announcement to the defendants. They did not flash any lights. They did not call out. They weren't even sure if the defendants heard them. So it's clear that they were walking for 15 to 20 minutes, certainly well over 75 yards because they walked past all these buildings. So I think the key issue really here is where is the connection between these buildings and this intent that they're supposed to establish?
Can I ask you about the walkie-talkies? I mean, how is that related to work? I mean, the ordinary tools, I mean, it's one thing to have a screwdriver and a crowbar, but walkie-talkies tuned to the same
The only thing I can suggest certainly to that is that people use walkie-talkies to communicate that are in different sections of a building. That's what was testified at the trial by Mr. Angier. Mr. Squire didn't testify to anything with respect to the walkie-talkie except the fact that he had Mr. Angier's jacket on that it contained a walkie-talkie.
And they both were tuned to the same channel?
That's the evidence that was presented, yes. I can't speak to that. Certainly, there are reasons to have walkie-talkies to communicate from far distances, whether that's different levels of a building or different areas of a property.
And we're dealing with evidence in the light most favorable to the Commonwealth at this point.
Certainly, but at the same time, there has to be some evidence of intent, and I don't see anywhere in this case where there was evidence of the intent
With the intent connected to the building.
to a place,
yeah.
to some place. That's
Wasn't it the plaza, though, the convenience store, maybe it was 7-Eleven, was about to close and it hadn't quite closed yet? Super Bowl Sunday, it's pretty desolate there. And if you take all of these facts individually, it doesn't add up to very much, but it could have been that they were going down the tracks and waiting out the time a little.
anything's a possibility. They could have been going down the tracks and where they were doing anything, whether that's smoking marijuana or
I know that, but
whatever they were
I'm
doing.
not pulling it out of the air,
Right.
though. I'm saying that I think the evidence was someplace hadn't quite closed yet, and every place else had.
I think certainly in this instance, if they had made any step towards any building, closed building, I think that would have been enough. I think the problem is that there was no overt action by the defendants to go towards any place with these alleged burglars' tools, or tools that could be used to burglarize a building.
Were the two of them found together?
They were both walking together, as far as I recall from the testimony. I believe they were walking side by side. And they walked up and approached the two officers who later identified themselves as officers and to stop. With respect to the closing statements, in and of itself, the suggestion that someone's story is not credible certainly is acceptable. The problem that I see with the closing arguments is that not only does the assistant district attorney state that the testimony isn't true on a couple occasions, the second time when he appears to be talking about the map in the jacket, he says that's just not true. Based upon the fact that this was a relatively weak case as far as the evidence that was presented, I would suggest that is improper and is a justification for a reversal as well. With respect to the jury instructions, my key issue with it is the place. There was no direction as to what place they were allegedly trying to break into. There was just that they had burglars' tools and they had an intent. Well, did they have an intent to break into what? There was never any indication as to what place this was supposed to be. And if there are no further questions...
I'm sorry, so your view is that the judge should have said that it is an element of the offense that you must find what?
That one of the buildings were intended to be broken into. There was a specific building. There was whether that was the White Hen Pantry, the office, the gym, or whatever building that there was the intent to, again...
And there was no mention of any...
I don't believe so. I don't believe so.
Is this, you probably talk about this, but is this did the instructions the judge give, are they the model instruction, district court instructions?
They were very similar.
I mean, here's the real question. Do the model district court instructions have some reference to place?
I can't speak to that, unfortunately. I am not 100% sure.
So, if you win, what is the standard we set with regard to tools which are not specific to burglary? The prosecution must show what?
That there either has to be some overt action taken by the defendants to connect them to a place, or there has to be some steps taken. You know, in many of the cases, they're already next to a car or a house they're either walking away from a house that's been broken into, they're next to a car that's been broken into, there's some other evidence that connects them, whether they have a map or they have tools, there's something else that connects them to the actual place or vehicle that's being broken into.
And is that simply transforming this crime into one of attempted burglary?
Oh,
or-
that's a good question, I hadn't thought of that.
But it appears that it's not historically been viewed, it's been viewed as something less than attempted burglary.
I hadn't even considered that.
Do you want us to reverse this 1857 case?
Well, I certainly think that we're here for a reason, and I think that the intent is probably the biggest issue here. Although I believe the closing arguments have an issue as well. I believe the intent is really the strongest issue.
Okay, thank you.
Thank you.
Ms. Hill, you haven't changed a bit. Welcome back.
Good morning again, Your Honors. I'm asking this court to affirm the conviction of Mr. Squires because the evidence was sufficient, the jury instruction was proper, and the prosecutor's closing argument was not improper. In this case, the defendants are observed arriving at the Rama Center Plaza in Norwood. It's around 11 p.m. at night. The 7-Eleven was just closing. They back into a parking spot in front of the China Rama restaurant. And on that point, I need to make a correction in my brief on page 12 at the bottom. I stated it was Angier's car, but it was actually this defendant, Squires' car. And that's consistent with what I've written in
And the
the
restaurant's
rest of the
closed?
brief. I'm sorry?
Is the restaurant closed?
As the record indicates that when asked what businesses were open, the officer testified that the 7-Eleven was just closing.
Now, did the engineer say that the tools were for work?
Angier said that they were work tools.
Okay, so-
And Squires said that they were work tools, and they elaborate on that in their testimony
Right.
later on.
And yet they take the tools with them out of the car and walk down the trail with them.
They do, and this isn't a toolbox with measuring
Then
tape.
it's in I thought it was in backpack.
It was in a backpack. I'm saying it's not a toolbox. These are two tools that are not found with any other tools. It's not as if they're carrying their toolbox. There's no measuring tape, there's no screws, and these are two.
Well, it's his livelihood. Maybe he doesn't want somebody to break into the car when they see a backpack.
Well, Squires did leave a sledgehammer in the car, but these are big, heavy.
Good for the defendant, right?
These are big, heavy tools. There's pictures of them in the supplemental appendix, and in those pictures, there's a 12-inch ruler. These aren't the kind of tools. Mr. Angier testified that, or Squires indicated to the police when he stopped that they were just out for a stroll, and these are not tools that one would normally carry with them when just out for a stroll.
But
because
they
they're
aren't
large, heavy
adapted for
tools.
any malevolent purpose, though. I mean, they're still just tools.
They are
right?
just tools, Your Honor, but they are not construction tools. These are destruction tools, and they're not found in.
What do you mean, destruction tools?
Well, they're tools that are used to break things. This is
In construction, right?
to take things down in the course of construction.
So they're
but-
construction tools.
Yes, but in the course of construction, it's breaking down something in order to build it. this is just a long screwdriver. It's not found in conjunction with screws. And this is a large pry bar that's used for breaking items apart. The intent for the tools can also be inferred not just from what they were possessed with in terms of tools, but in terms of the defendants each possessing a walkie-talkie turned on, both tuned to the same channel. Mr. Squires was wearing Gorilla Grip gloves, which were black gloves with a gripping surface on them.
Was it cold outside?
It was cold, it was below freezing in the teens and 20s, and there was testimony that these gloves were not insulated and not weather appropriate. They were work gloves.
So you don't disagree that the tools were not what we would consider burglarious tools in and of themselves, that they were, in fact, ordinary tools?
I agree that these are ordinary tools and that the burglarious intent can be inferred from the context in which they're found, not along with any other tools, and in that the defendants are walking on the railroad tracks, which is in and of itself a crime for which they were both convicted and which is not raised here, and that they're both carrying walkie-talkies, and in conjunction with the map, the hand-drawn map, which is in the co-defendant's backpack.
What about the contention regarding the connection that's necessary to some place?
There's no requirement that a place be identified. Possession of burglarious tools is a crime of possession. The crime is complete once the tools are possessed or mended or made with the intent that they be used to break something.
Is that the
To
Tivon
break a
case?
specific place, a specific intent to steal or commit the crime in that place, right?
There's a specific intent that the tools be used to break something, and that a crime, usually larceny, but any other crime, be committed in that place. But it's a general intent crime, and that is the Tivon case, that the crime is complete once the tools are procured, that it's a general intent, and that it's not necessary to prove a particular place. And the appeals court noted that, citing Tivon in Faust in 2012.
It has to be someplace, though. I can understand that. It doesn't have to be a particular place, but the Commonwealth does have to show that the intent is not just to possess the ordinary tools, but to possess them with the intent to break something, right?
I agree with that, Your Honor. And I would argue that in this case, the hand-drawn map shows that there is some place that the defendant's designed to break into. However, the Commonwealth does not need to show that there was a particular place. In fact,
Well, what place, I know, not a particular place, but what was the evidence about what they were going to break into?
Well, there's evidence that they're in an area of closed businesses. There's a 7-Eleven, a child care center, a number of restaurants.
But they were going away from the buildings, though, right?
They were still in an area, they're walking south from Norwood Center, so they're still in an area where there are buildings. They're basically behind where the buildings are on the train tracks. But the Commonwealth doesn't need to prove that they had formed any intent at this time to break into a particular place. It's helpful when we're trying to infer what the intent for these tools are. But the crime is complete once an individual possesses these tools and has some intent to use them, even far into the
So the intent is
future.
established just by being in an area where there are buildings? Is that what you're saying?
No, I think that's helpful, particularly when looked at with the hand-drawn map, which clearly depicts the train tracks, a building, arrows, and the words going in. But it's also, I think we look at the circumstances that they're trespassing on the train tracks. They have, Squires has the Gorilla Grip gloves on. They have walkie-talkies that are turned on and tuned to the same channel. There's a flashlight and another pair of gloves within the backpack. There's a sledgehammer in the car. Squires left his dog in the car, so it's not as if they're out for a walk with the dog. And that they're a little bit elusive with the police when stopped. Squires indicates that they're coming from down there and gestured southward when the officer knew that he had left the Rama Center parking lot. And then when asked to be truthful, the defendant, Squires, states that they were just out for a stroll.
Okay, I can understand that being a reason to stop them, but proving the crime beyond a reasonable doubt, requires a little bit more than what you have here, doesn't it?
I think, well, there's a reason to stop them because they're on the train tracks, which is
Okay,
itself a crime.
that's what I mean.
And then beyond that, they're in possession, all of the circumstances need to be looked at, and what the jury here really has to find is that these tools that the defendant are carrying are burglarious rather than just regular tools. And I think the jury can make that inference in this case for all of the facts that I've just recited for the court.
I'm just looking at the model instruction, district court instructions that are in the, I think it's the brief that Mr. Angier filed. So the fifth element that needs to be proved, according to the district court, is that the defendant had the specific intent of stealing or committing the crime in that place. So there is some place that needs to be, at least if the district court instructions are correct.
I think, Your Honor, that the district court instructions are correct, and I think the appeals court notes that in Redmond.
Well, so in response to Justice Hines, it says there's a specific intent of stealing from that place or committing a crime in that place.
But the reference to in that place is to a building, room, vault, safe, or other depository.
But if you don't have any evidence at all of that's what's happening, I'm just, what do you do about that?
It's a crime of possession, and the evidence has to be that the defendants intended to use the tools at some place. But the place doesn't need to be specified, and I would argue, in fact, that while in this case the defendants did have a place in mind, that one could be convicted of burglarious tools without having any kind of plan in mind at all.
Suppose they were in a field, walking on railroad tracks, and there are no buildings around. I mean, is that enough?
Depending on the kind of tools one's carrying.
Same facts, except they didn't walk from parking at the whatever you call Rama, China Rama, but they're just out there in the field.
I think it's a little bit less, but I think the inference still could be drawn that these defendants
You don't have to
intended
you don't have to point to any place that they could have broken into.
No, Your Honor.
That doesn't seem like, I mean, I don't know how to understand the intent to use the tools to break into some place if there's no place in the area to break into.
This is a crime of possession within.
Well, I get that, but I mean,
well, when
one thing if they were, I suppose, if they were burglarious tools in themselves, but you've just said that they're not. They're ordinary tools.
And the analogy in the Tivnon case, which is the first case to analogize this, to examine this statute in 1857, compares it to possession of counterfeit notes with intent to utter them. That the crime is complete once one has these notes, and that intends to use them at some future point in time, but may not have gotten to the point in one's thinking where we figured out where we're going to pass the notes. Or I would argue it's similar to possession of a controlled substance with intent to distribute it, where someone's in a home packaging up cocaine but hasn't identified to whom they're going to make a sale
Well,
of these items.
you don't have counterfeit money unless you intend to do something with it.
Exactly.
That's not the case with tools. You can't say that somebody intends to do something just because they have them.
If somebody, I agree in this case. If someone had either tools that are blatantly, that are obvious that they're burglarious from what kind of tool they are, whether they be lock picking or whatever, or work tools, there's no crime unless the individual intends to use those tools to break into something and to also commit some crime there. But the defendant doesn't need to have formulated a plan or taken any affirmative steps towards doing that. And in fact, somebody could possess these same tools in a home, not doing anything with a burglarious intent. Of course, the only way that would be able to be proven would be, if there was some sort of plan written out, or if we were able to read somebody's mind.
So help me with the inference that you draw from their walking away from the store. How does that lead to an intent to burglarize one of the stores?
So they're walking. They walk directly through a parking lot to an alleyway down an embankment, over a creek, and up onto the railroad tracks. And this is an area, it's a shopping plaza with railroad tracks going behind it, and there are buildings on either side. It's a business district, Norwood Hospital is right there. So there are any number of buildings that could be broken into. It may not be that it was the China-Rama or the 7-Eleven, but certainly it was a building shaped like the one depicted in the hand-drawn map, which is depicted in the supplemental.
And I gather there was no place connected which had this sort of side door or this door. I mean, this is an unusually shaped building,
It is, Your Honor.
but there was no place along, there was no evidence that, this is a door that is a side door with a building of this shape that's along that route.
I think the jury could have inferred that there was a specific place, that this was a specific place, but there was no testimony that this matched a particular building.
Okay, so you're the inference from them walking, and I'm sorry, they're walking away from the Chinese restaurant, not back towards it when they were stopped?
It's a sort of a U-shaped plaza. They walk toward the base of the U and then head out on the railroad tracks.
Right, but when the police stopped them, were they walking back towards the police, or were they walking further away from the?
The police are behind them. They then turn around and walk north towards the police and act as if they're going to pass the police and have to be asked to be stopped twice.
So the inference, which you think is the most likely, is that they were simply parking their car for a quick getaway at that 7-Eleven area, but that they intended to rob someplace along the side of the tracks? Is that the strongest inference you have?
I think that is the strongest inference, Peter. They're backed into this empty parking lot. There's nothing else open, and they're walking behind where these buildings are.
But the problem with that is that you leave a sledgehammer pretty far away from your intended place of entry.
I agree with that, Your Honor, but again, the defendants don't need to have a particular plan in mind for these tools. Then we're getting into an attempt to break and enter, which is a separate crime. I would suggest in this case that the jury instructions were proper. They were read almost verbatim from the model instruction, and that the prosecutor's closing argument was within bounds and proper. For all of those reasons, I would ask the court to affirm.
All right, thank you.